Welcome back to the deep dive. Today we are shifting gears just a little bit,
Yeah, we're taking a very specific approach today.
right? Because we know a lot of you listening right now fit a very specific profile. We kind of internally call you the planner.
The planner,
You
yes.
know who you are. You've got a stack of notes on your desk, maybe a highlighter in your hand, and you are deep in prep mode for a professional exam.
Could be the bar exam or urban planning certification.
Exactly, or public administration. And we know you need more than just a good story here. You need a structural framework.
You need something you can actually use on exam day.
So consider this deep dive your audio study guide. We're going to take one specific, really crucial case and just cement it into your memory so you can recall it effortlessly when it actually counts.
It's a really good strategy, honestly. And the case we're tackling today is an absolute heavyweight in Canadian administrative law and Aboriginal rights.
Oh yeah, it's massive.
We are looking at the Supreme Court of Canada judgment, Clyde River Hamlet versus Petroleum Geoservices, Inc.
From 2017, right?
Yes, from 2017. If you are studying the duty to consult, this is a foundational text. You have to know it.
But I want to be clear, this isn't just some dry legal textbook text.
Oh.
It's a classic conflict. You've got a small hamlet in the Arctic, massive seismic testing ships, and a literal battle over the essential food source of the Inuit people.
The stakes are incredibly high in the real world.
But before we get into all the drama on the ground,
Yeah.
let's set the mission for our listener. What is the core legal concept they need to walk away with today?
Right. So the mission is to fully understand the intersection of the duty to consult and the modern regulatory state.
Okay.
Specifically, how does the Crown's duty to consult Indigenous peoples interact with independent regulatory bodies, like the National Energy Board, for instance, the NEB?
Because the big question for your exam is probably going to be who is actually responsible for the consultation.
Exactly. Is the minister, is it the board itself?
Can the government just sort of hand it all over to a tribunal and wash its hands of the whole thing?
Right. And this case answers those exact questions.
Okay, let's get into the facts first. So we have the context. We are up in Nunavut. Set the stage for us. Who are the actual players here?
On the appellant side, we have the Hamlet of Clyde River, the Namotak Hunters and Trappers Organization, and the mayor at the time, Jerry Netnine.
So these are the people representing the community that's directly affected.
Yes, exactly. And on the respondent side, we have the seismic testing companies. So that's Petroleum Geoservices, Inc., or PGS, along with their various corporate partners like Multi-Client Invest.
And what exactly was PGF proposing to do out there?
They applied for authorization to conduct offshore seismic testing in Baffin Bay and the Davis Strait.
Which sounds very scientific and quiet, but it's not.
No, not at all.
Yeah.
For a layperson, it sounds like science, but practically it involves towing these massive air guns behind a ship.
Right.
And these guns fire incredibly loud blasts of compressed air straight through the water column. We're talking decibel levels that are almost hard to comprehend.
Just blasting the ocean floor.
Yeah, to map geological resources like oil and gas under the seabed.
And they wanted to do this right next to where the Inuit live. Which brings us to the rights at stake. We aren't just talking about, people not liking loud noise in their backyard. This goes back to a very specific legal document, doesn't it?
It does. It goes back to the Nunavut Land Claims Agreement of 1993.
Okay.
Under that agreement, the Inuit ceded certain lands to the Crown, but, and this is the critical part for your legal argument, they retain the right to harvest marine mammal.
And this isn't just recreational fishing.
No, not at all. The source text makes it very clear that the Inuit rely on country food for their economic, cultural, and spiritual well-being.
The judgment actually lists specific animals, and I want to mention them because it highlights the specificity of the threat here. We're talking about ringed seals, bearded seals, harp seals, the narwhal, and the bowhead whale.
The stakes were just astronomically high for the community. The Inuit argued that the sheer noise from the air guns could cause permanent hearing damage to these mammals.
Which is terrifying.
Right? And alter their migration routes entirely.
Mm.
If the animals move away or if they die, the food source just disappears.
And the source notes that in these really remote communities, the cost of imported food is just incredibly high.
Yes, we are talking about basic food security and survival here, so the potential infringement of that treaty right was severe, very severe.
Right. So you have a massive project that threatens the primary food source of a community with established treaty rights. Now let's look at the process. Who gave the green light for this testing?
That would be the National Energy Board, the NEB. Back in 2011, the proponents applied for authorization under the Canada Oil and Gas Operations Act, or CUGUA.
Okay, go.
And the NEB launched an environmental assessment to decide if this project should go ahead.
And Clyde River immediately opposed it, right? They filed petitions. They argued the duty to consult hadn't been met.
Hmm.
But the NEB issued the authorization anyway.
Yeah, they did. The NEB concluded that significant adverse environmental effects were unlikely, which is quite a statement. So Clyde River then applied for judicial review at the Federal Court of Appeal.
And this is an important beat for the narrative.
It is because they lost. The Federal Court of Appeal dismissed their application entirely.
Wait, they lost at the Federal Court of Appeal. On what grounds?
The court essentially said that the Crown was entitled to rely on the NEB's process to fulfill its duty to consult. They felt the process was legally sufficient.
Wow.
But obviously, Clyde River didn't stop there. They appealed to the Supreme Court of Canada. And this is where the legal analysis for your exam really opens up.
Right.
The Supreme Court allowed the appeal, and they actually quashed the authorization. But to get to that conclusion, they had to answer 4 specific legal questions.
Okay, planner, this is where you get your pen ready. We're going to walk through these 4 questions one by one because they form the entire structure of the judgment.
Yes. Here's your roadmap. Question 1 is the trigger. Can an NEB approval process trigger the Crown's duty to consult?
Okay.
Question 2 is reliance. Can the Crown actually rely on the NEB to fulfill that duty? Question 3 covers the NEB's powers. What is the NEB's role in considering consultation before granting an approval?
And the last one.
Question 4 is the application. Was the consultation adequate in this specific real-world case?
Okay, let's start with question 1, the trigger. Because the government tried to argue something pretty clever here.
They really did.
They said, look, the NEB is an independent tribunal. It's not, quote unquote, the Crown per se. It operates at arm's length from the minister. So if the NEB makes a decision that's not Crown conduct, so the duty to consult isn't even triggered in the first place.
It's a very technical legal argument, but the Supreme Court rejected it entirely.
Thank goodness.
They clarified that, yes, the NEB operates independently of government ministers, meaning the minister can't just call them up and tell them how to vote on a project.
Right. That would defeat the purpose of an independent board.
Exactly. But the court said the NEB still acts on behalf of the Crown when it makes a final decision on a project application.
The court used a very specific term here, I remember. The vehicle.
That's the key metaphor to write down. The NEB is the statutory vehicle through which the Crown acts.
I like that.
The court was super firm on this. The Crown cannot evade its constitutional duties just by delegating power to a regulatory body. If the state empowers an entity to make decisions that affect Indigenous rights, then that entity's actions invoke the Crown's honor.
So simply put, yes, an NEB decision absolutely triggers the duty to consult.
Yes. Trigger established.
Okay, so the duty is triggered. That leads us right into question 2, which is reliance. The Crown essentially says, fine, the duty exists, but we're busy. We have this massive expert body, the NEB, that does hearings and assessments all day long. Can't we just let them handle the consultation for us?
And this is where the law gets very nuanced. The answer is yes, but there is a massive catch.
Always a catch.
Always. The court ruled that the Crown can rely on regulatory bodies like the NEB to fulfill the duty to consult either in whole or in part. The legislature has the statutory authority to empower bodies to do this work.
But the Crown can't just walk away, right? Like, they can't just wash their hands.
Yeah. No, they absolutely cannot. Think of it like a homeowner hiring a general contractor to fix a roof.
Okay.
You can hire the expert to do the actual physical work. You rely on their skills. But if the roof still leaks and ruins the living room, you are the owner.
It's your house.
It's your house. You are ultimately responsible. The Crown holds ultimate responsibility here. They can outsource the procedural aspects of consultation to the NEB, but they cannot outsource the legal responsibility.
Okay, so if the NEB process leaves gaps or just doesn't do a good enough job,
Then the Crown has to step in. If the regulatory process doesn't achieve adequate consultation or accommodation, the Crown has to fill those holes.
how do they do that?
Maybe by pausing the decision or issuing supplementary measures directly.
Yeah.
They just can't point at the NEB and say, hey, talk to them. It's not our problem anymore.
That distinction between procedural reliance and ultimate responsibility is totally crucial for the exam. Note that down. Now, moving to question 3. This is about the NEB's actual powers. Let's say the NEB is going through the motions and they realize, hey, the Crown hasn't consulted these people nearly enough. Can the NEB actually do anything about it? Or are they stuck just looking at technical environmental data?
This goes right to the heart of the NEB's mandate. Under COGO and the NEB Act, the board has really broad powers to hear evidence and decide on questions of law. But the court went even further in this judgment. They linked this regulatory power directly to the Constitution.
Specifically Section 35.
Right. Section 35 of the Constitution Act, 1982. The duty to consult isn't just some nice government policy, it's a constitutional imperative.
Right.
The NEB is charged with acting in the, quote, public interest. And the court made a very powerful statement here. They said a project authorization that breaches constitutional rights simply cannot be in the public interest.
That is such a strong line. You cannot separate the public interest from the Constitution.
Exactly. So logically, if the Crown's duty to consult remains unfulfilled, the NEB is not just allowed to withhold approval, they must withhold approval.
They have to say no.
They have the power and the strict duty to say no if the constitutional obligations aren't met. And they also have the power to attach conditions to an approval to actively accommodate those rights.
So the NEB is effectively a guardian of the Constitution in this specific regulatory context. They aren't just technical auditors ticking boxes.
That's exactly the takeaway. They are a constitutional backstop.
Right, so we've established the legal framework perfectly, triggers reliance powers. Now we get to the actual facts of the case. Question 4, was the consultation adequate in Clyde River?
To answer that, the court first had to determine what level of consultation was required. Because remember, consultation isn't just one size fits all, it's a sliding spectrum.
Right, depending on the situation.
Yeah.
And for Clyde River.
It was at the very deep end of that spectrum. Deep consultation.
Why deep consultation specifically in this case?
Two main factors drive this analysis. First, the strength of the claim. The Inuit had firmly established treaty rights here, the right to harvest marine mammals.
These weren't just vague assertions.
No, not at all. They were settled law under the Land Claims Agreement. Second factor is the severity of the impact. The risk here was what they call non-compensable damage.
Meaning you can't just buy your way out of it.
Right. If you destroy the migration route of the bowhead whales, you can't just write a check to the hamlet to fix it. The cultural and economic loss would be profound and permanent. So strong rights plus high risk equals deep consultation.
Okay, so the legal bar was set very high. But what actually happened on the ground? Because looking at the source text, it seems like the process was lacking, to put it mildly.
It was a procedural disaster, frankly. The court identified a whole laundry list of failures. And if you were asked to provide examples of bad consultation on an exam, you need to memorize these.
Let's run through them. Failure number 1.
A misdirected inquiry.
Meaning what?
Meaning the consultation focused almost entirely on environmental assessment science. Measurements of air guns, sound waves, geological data. It completely ignored the actual impact on the rights of the Inuit.
So they were basically asking, is this loud, instead of asking, will this violate your constitutional treaty right to harvest?
Exactly. The NEB treated the whole thing as a science project instead of a constitutional inquiry.
Wow. Okay, failure number 2. Funding.
There was none.
None at all.
Zero. In complex regulatory hearings, participant funding is very often provided so that local communities can hire their own experts or lawyers to help them actually understand the data being presented.
Because it's highly technical.
Right. In Clyde River, the Inuit were given absolutely no resources. They had to rely on their own limited municipal funds to fight a multinational oil consortium.
Which is truly a David and Goliath dynamic. Which leads us to failure number 3, and honestly, this one is the most shocking practical detail in the entire case for me.
Right.
Accessibility. Because the proponents said, hey, we provided all the info you asked for, but how did they provide it?
They dumped a 3,926-page digital document on a website.
Nearly 4,000 pages.
Yes, in Nunavut. We really have to remember the geographical context here. Internet bandwidth in the far north is often incredibly slow, and it's very expensive. Downloading a PDF file of that massive size was practically impossible for most community members.
So it was a data dump, not actual information sharing.
Exactly.
And what about the language barrier?
Well, only a tiny fraction of that massive document was translated into Inuktitut. I think just the executive summary was translated. But the dense technical details where all the actual risks to the whales were hidden, those were in English only.
That's awful.
For the elders and the hunters who possessed the actual traditional knowledge of whale migration, the document was essentially a crosstalk.
So you have a 4,000-page English PDF that you literally cannot download describing a project that might destroy your entire food source. And when the community tried to ask questions during the few meetings they had, what did they get?
They mostly got circular answers. The proponents held meetings, sure. But when someone asked a direct question like, can this noise actually kill a narwhal? The proponents would often just give vague assurances or refer them right back to that untranslated, undownloadable document.
So there was no real dialogue.
It was a monologue, the proponents talking at the community.
And were there oral hearings? Like
Uh,
a formal chance for the Inuit to speak directly to the board?
no, there were not. The NEB conducted the entire review in writing, which again completely ignores the oral tradition and culture of the Inuit.
It really seems like the proponents and the NEB were just checking boxes on a form.
Yeah.
Did we post the file? Yes.
Yeah.
Did we hold a town hall meeting? Yes.
Yeah.
Okay, we're done here.
That's effectively what happened. The proponents made some very minor concessions, like they offered passive acoustic monitoring to listen for whales before firing the air guns.
But that's it.
Pretty much. And the Inuit felt this was totally insignificant compared to the existential risk to their food supply.
And I want to pause here and bring in a comparison case, because this is vital for understanding the law and how courts view this. The Supreme Court actually released the Clyde River decision on the exact same day as another major case, Chippewas of the Thames First Nation versus Enbridge pipelines.
Right. This is the compare and contrast portion of your exam prep. Pay attention here. In the Chippewas case, the situation was legally very similar. It was an NEB approval, and the duty to consult was triggered. But the outcome was the exact opposite.
The Supreme Court upheld the consultation in Chippewas, right?
They did, yes.
Why? What was the major difference?
The process itself. In the Chippewas case, the NEB provided actual participant funding. They held extensive oral hearings where the First Nation could speak directly to the ultimate decision makers.
Okay, so real dialogue.
Yes. The notice given to the nation was clear and it was early. The Crown also explicitly stated that they were relying on the NEB process to fulfill their duty, and they made that very clear to the First Nation up front.
So in Chippewas, the mechanism worked because the vehicle of the NEB was actually equipped to do the job properly.
Precisely. It shows that the NEB absolutely can fulfill the duty to consult if the process is robust, if it's funded, and if it's accessible.
Right.
But in Clyde River, the vehicle basically had 4 flat tires. The complete lack of funding, the lack of oral hearings, and the accessibility issues meant the duty simply wasn't met.
So going back to Clyde River, what was the final ruling from the Supreme Court?
The Supreme Court allowed the appeal. They formally declared that the Crown had breached its duty to consult.
And the permit?
Consequently, the NEB's authorization was completely quashed, meaning it was legally canceled, the seismic testing could not proceed.
And the court awarded costs to the Inuit, too, which is a really significant signal that their fight was just.
It completely vindicated their position that this wasn't just about NAMBYism, not in my backyard. It was fundamentally about protecting constitutional treaty rights.
This brings us to the quote-unquote so what for our planner listening right now. If you are staring at a blank page on exam day, and the clock is ticking, how do you synthesize all of this into a solid answer?
You need to hit 4 main points clearly. First, the trigger. The NEB acts on behalf of the Crown. Its decisions trigger the duty to consult. The Crown cannot hide behind a regulator.
Right.
Second, reliance. The Crown can technically rely on the NEB's process, but it retains ultimate responsibility. If the NEB fails the process, the Crown fails the Constitution.
Good phrasing.
Third, the NEB duty. The NEB is legally empowered to decide constitutional issues. It must withhold project approval if the duty to consult isn't fully met.
And the fourth point?
Fourth is the failure. In this specific case, the consultation failed because it wasn't deep. It lacked participant funding, it lacked oral hearings, and it lacked basic human accessibility like local translation and manageable digital file sizes.
That accessibility point is really the one that sticks with me long after reading this case. It transforms the concept of consultation from a sort of dry legal abstract into a harsh practical reality.
It really does. And it leads to a somewhat provocative thought I want to leave you with as you study. We often think of consultation as just a formal legal step, a box to check on a government workflow form.
Yeah, a bureaucratic hurdle.
But Clyde River challenges us to critically look at the difference between mere bureaucratic access and actual practical access.
Right.
Think about it. If a government body follows all the written rules perfectly, they post the official notice, they upload the massive PDF, but they do it in a way that the affected people simply cannot engage with. Did a consultation actually happen?
The Supreme Court definitively says no.
Right. Access has to be tangible. It must be respectful of the real technological and linguistic reality of the actual people you are talking to.
You can't just ignore the context of the community.
Exactly. It challenges every planner, every lawyer, and every regulator to look beyond their paperwork and ask a fundamental question. Are we actually communicating with this community, or are we just broadcasting at them?
That is a vital lesson for anyone going into this field. Don't just check the box. Make sure the box is actually open.
That's the lesson.
Yeah.
Perfectly said.
All right, planner. You've got the full framework now. Clyde River versus PGS. Remember the trigger, the reliance, the power, and the practicality. Cement that in your mind. Review your notes. You're going to do great. Good luck on the exam.
Good luck out there.